Do grandparents have the legal right to see their grandchildren in Connecticut? This is a common question I hear as a family lawyer, and the short answer is that grandparents do not automatically have visitation or custody rights. Not even if they're loving, not even if they're very involved, and not even if the parents cut them off completely. I'm Matt Dolan with Dolan Divorce Lawyers in Connecticut, and today I'm going to explain the law on grandparents' visitation rights. Now, before we talk about grandparents, we have to talk about parents. Under both U.S. Supreme Court law and Connecticut law, parents have a constitutional right to raise their children as they see fit. That means that courts must give special weight to a fit parent's decision, including the decision to say, I don't want my children having contact with certain people, and that even applies to grandparents. So the court is not starting from a neutral position. It starts by assuming that the parent's decision is correct. Now, in Connecticut, a grandparent asking for visitation must prove two very specific things, and they must prove both of those things. First, they must establish that a parent-like relationship exists. The grandparent must show they had a relationship with the child that was similar to that of a parent, not just a loving grandparent relationship. That usually means things like the child lived with the grandparent was a primary caregiver, and the grandparent handled daily routines, things like school, medical care, meals, and bedtime. And here's what usually is not enough: things like weekend visits, holidays, babysitting, and a close emotional bond. Those things matter emotionally, but legally, they often don't meet the standard that is required. And second, the grandparent must show that a real and significant harm would be done to the child if they did not see the grandparent. And this is the part that most people don't expect. The court is not asking, would visitation be good for the child? The court is asking, will the child suffer real harm if visitation is denied? That means emotional harm, psychological harm, or developmental harm. And it has to be more than sadness or disappointment. Missing grandma is not enough. Being upset is not enough. There must be evidence that the child will be meaningfully harmed without the relationship. These cases can be very hard to win because courts are protective of parents' constitutional rights. Judges don't want to undermine parental authority, and the courts worry about opening the floodgates to third-party visitation lawsuits. So if you're a grandparent dealing with this situation, try mediation or family counseling before going to court. Document your involvement before access is cut off. Avoid confrontations that make the situation worse, and talk to a family law attorney before you file anything. And for parents watching this, courts generally support your right to make decisions for your child, but in rare, extreme cases, a total cutoff can raise legal issues, especially if a grandparent truly acted as a parent in the past. So those are the basics on grandparents' rights here in Connecticut. These cases are fact-specific and can be both emotional and legally complex. So as usual, if you have any additional questions, you can contact our office. And if you are looking for representation in a grandparent's rights or other family law case here in Connecticut, we would invite you to contact our office as well.